So for those who've just joined us, I would like to acknowledge I'm coming from the lands of the Wurundjeri people of the Woiwurrung language group today. We pay our respects to Aboriginal and Torres Strait Islander people, past and present, and any First Nations people in the session today. And as we know, violence against women is widespread and touches the lives of many people. We know the content discussed today may be emotionally challenging. You can contact the numbers on the screen if you wish to speak with someone following our session today. These links and support services will also be provided into the chat along with our code of conduct for today's session. So if you have a question you would like the panelists to answer, please use the Q&A function at any time and indicate who the question is for. We will address these in the Q&A towards the end of the panel discussion. Okay, so before the break, panelists discussed the impacts of the legal system on how victim survivors are portrayed in the media and some positive actions that media can take in their reporting to ensure they're not contributing to further harm. We'll now go into maybe some of the nitty-gritty around reporting on cases of violence against women which might be before the courts. What kind of things do you need to consider in your reporting? And how can you navigate some of the challenging legal restraints that exist in Australia while still doing good reporting? So whether you are a seasoned court reporter or whether you report on sports or social affairs, we hope that you'll find the session today valuable for your work. So joining us today are two excellent minds in media law and ethics. Please welcome Gina McWilliams, Senior Counsel at News Corp, and Mark Pearson, a former journalist and journalism educator and adjunct professor at Griffith University. I'll also welcome back the brilliant moderator of the former panel, Elena Campbell, Associate Director at the Centre for Innovative Justice, RMIT University. And Elena will be joining us towards the end of the conversation to share her expertise and bring in some of the learnings from the first part of this webinar. So, Gina, I might start with you. So you've been a pre-publication lawyer and senior counsel at News Corp on Holt Street for 20 years now. Among many other significant achievements in that time, you were part of a team that was awarded the 2021 June Andrews Walkley Award for Women's Leadership in Media for the very powerful #Let Them Speak campaign with journalist Nina Fennell. And that campaign worked to inform the public about sexual assault victim gag laws in Tasmania, near the Northern Territory and Victoria. You must have gained a very detailed understanding of the different types of legal restrictions over your years at News Corp that journalists and media outlets need to consider when telling a story. Can you briefly touch on some of these, particularly those that are most relevant to reporting on sexual harassment and assault, domestic and family violence, femicide, and so on? Do you have any practical advice that journalists can consider to stay on the right side of the law?
Sure. Let's start with the small things, shall we? Like the little teeny tiny ones, and we'll work our way up. So when a pre-publication lawyer is asked to advise on a piece of copy, we have numerous balls of legal knowledge going on around that we know might potentially apply to a particular story. Now, the tricky thing about what tends to happen in the domestic violence space is while, say, 2 or 3 of these things might be triggered by your standard piece of editorial, your news piece that's in the front of the newspaper, when it comes to domestic violence articles, it could be all 5 or 6 things that we are thinking about which are triggered. It just takes the right story to do those. So the 6 in particular that kind of roll around, obviously there's defamation to consider. That's the case with any type of news publication. Sub judice contempt if there are court proceedings on foot, automatic statutory restraints which prohibit publication, and if there aren't automatic restraints, whether there's been a court order made, a non-publication or suppression order. Intellectual property. We have a brand new ball from which kicked off in June this year, which is the tort of privacy, which is also something which we now need to consider whenever we're giving advice about this area. And then lastly, there's a big catch-all ball, which is everything else that might possibly be a legal issue which impacts on a story of this kind. So generally speaking, as I said, it is possible for all of these things to be triggered by a story that involves domestic violence. But the 2, I think, well, let's say 3 that are probably the most pertinent are the ones that you've already touched on, Rebecca. Defamation, obviously. is a huge issue. Are there court proceedings, i.e. do you have a sub judice contempt issue that you actually need to take into consideration? And partnered with that, because the two often go together, is there an automatic statutory restraint which applies to this story, or is there a non-publication order that has been made? Now, if you're looking at defamation, there's usually two principal things that you can do to have in your toolbox, which could reduce the risk of the story that you're about to produce. The first one is, despite the fact that there is no uniform defamation law in Australia anymore, it's splintered into a hot mess, as I like to call it. Every Australian jurisdiction requires that a plaintiff has to be identified from the piece of publication that they want to sue over. Now, you don't have to identify somebody by naming them or depicting them, although that will definitely do it. You could identify someone by providing enough information about who they are and perhaps what they do for a living or their social interests, or add a whole bunch of things together, and you are able to work out who the person is the story is about. It can be very effective in the domestic violence space to de-identify the story. And I say that particularly in circumstances where you may be dealing with a source who wants their story out there, but they're still very nervous about the circumstances in which the story is told, or they have a genuine fear that their former partner might perhaps use the publication as a means to bring litigation in a coercive fashion. And if that's the case, but they still very much want the story to be told, then de-identification not only deals with your defamation issue, but it may also mean that the person that you're dealing with is most comfortable about taking that approach. So there can be both a legal and a source protection rationale for doing it that way. If you don't need to de-identify, you've got a rock solid source, they're ready to go, they want their day in court, they're quite happy to get up in the box and give evidence to support what you want to write, then the second port of call for defamation is going to be a truth defence. There are obviously many other defences, but this is the one which is going to be the most important in the domestic violence sense. And it's going to be truth, not to that Joe Bloggs allegedly assaulted his wife. It's going to be that he actually did it. Because no matter how carefully you write your story, the aggrieved plaintiff, ex-partner, is going to say that you implied that he actually did engage in the violence that you are discussing. So that's, and that's actually kind of, in some ways, it's relieving to say that, because you don't have to worry so much about the imputations that you're actually implying, because they're always going to say it's the worst one. It's this actually did happen, not it allegedly happened. So that's kind of good. So what you need to know is, firstly, your source is comfortable about getting up in the box, so they're going to be able to give evidence, hopefully, on your behalf. As we all know, the biggest problem with domestic violence is that it tends to occur behind closed doors, and you end up in court with a he said, she said scenario. So what you're looking for as the lawyer is, in addition to your source who's the witness, contemporaneous documents which can help support the evidence that your source is giving. Now, the starting point for that these days is a lot of women who are experiencing this type of violence seem to have been starting to get quite good at diarising themselves. This happened to me on this day, or whatever it happens to be. That's a great starting point. Then on top of that, what are the other kinds of documents that might be around? Has this person made a complaint to the police previously? Has this person either had the police apply for an AVO, or have they applied for an AVO? Because if they have, there is an affidavit sitting on a court file which sets out exactly what your source says happened to them, which has put them in fear of the former partner sufficient to actually justify getting an AVO made in their favour. Maybe, unfortunately, it's medical records. Maybe they've had to go to a doctor or a GP or a hospital to seek medical treatment. If it hasn't gone that far, maybe they have sought assistance from a support service, and the support service may have notes that can show, you know, what the source said occurred to them at that particular time. And there are anything in that kind of area of documents is of use to you, because it helps show that the person that you're writing about has given that same account about what occurred to them more than once, and you can show that it's using those documents that it's remained consistent. And that makes it much harder for old mate to get up in the box and say, no, she's lying, that never happened, this is all complete rubbish. So the more documents you can get, the better it is. So in terms of tips, that's my number one tip for defamation. What are your contemporaneous documents that you can get that can actually help assist your source once you actually find yourself in a situation where you're going to potentially be engaged in defamation litigation? If it's not documents, are there maybe other people? I mean, it's unusual for domestic violence, but there may be other people who could potentially give evidence. Is there a neighbour who maybe observes some injuries to the person that you're dealing with? Would one of the doctors at the hospital that she attended be prepared to give evidence? You never know. You ask the questions and you find out, you know, what the scope of information available to you is. So again, in the defamation sphere, knowing perhaps also that the abuser was charged and potentially convicted, or charged and there are ongoing court proceedings, is important to know, because that will tell you whether you have a contempt problem. So that's always an important question to ask. If the person was charged and convicted, that gives you a lot of comfort in terms of defamation. So much so that you probably regard your risk as potentially having been quite high to being very low, because then we'll have the combination of the account that your source wants to give, but then you could potentially go and apply to access the court file, and you'd be able to do a report of court proceedings, which itself has a complete defamation defence under Australian law. So yes, if there were charges, it's good to know what stage they are at, because that gives you your contempt risk flavour. Moving on from there, the next question that I would be asking you is, what jurisdiction did this all happen in? And the reason for that is, as you might be aware, the laws that affect this area of publication are made on a state and territory basis, and sometimes even federal when it intersects with this area, which it can do. And while they tend to cover the same areas, for example, I think you might all be aware that there is nowhere in Australia now where you can identify the complainant in a sexual offence case without their consent. So that's uniform. What differs is, how do you get that consent and when can you get it? And that is very different depending where you are in Australia. So that's why it becomes very important to know exactly where the proceedings were being held. The next question which flows from that is, are there children involved in this case? Because that's a whole other set of messy automatic statutory restraints. And that is one area where, if there isn't already a statutory restraint, you will find that the courts are very fond of making non-publication orders, because they feel very strongly about protecting children who are going to be exposed to court processes in this area. And if that's the case, then the follow-up question is, have you contacted the court to see if there is an order in place? And you can certainly do that. There are court media advisors at most levels in all Australian jurisdictions. They should have that information that they should be able to give you. You are going to need to give them at least the name of the accused to enable them to look that information up for you. But they're there, and that's what they do. Yes, and then you knowing that you don't have an order that you have to worry about, you can just turn your attention to automatic statute restraints. And then the last question, which kind of fits into this set, is, are there any ongoing family court proceedings? Because that obviously is something which often exists in the same space. As you may all be aware, you cannot identify parties to family court proceedings. That's section 114Q of the Family Law Act these days, formerly known as section 121. Mark's smiling because he knows what I'm talking. I don't know why they changed it. It's like, just leave it alone. It was fine before. Anyway, the important thing about that provision, however, is that it is only triggered by producing an account of proceedings. So that is why it's not an offence to simply say that someone is divorcing someone else, because that's just a fact. That is not an account of the proceedings. But depending on the story that your source wants to tell, you might end up engaged in that area. So that's why you would need to know whether or not that is going to be an issue, and then you can change your copy up to make sure that you don't commit an offence against that section.
Thanks, Gina. Such important insights there. And, we know that when we're conducting training with journalists, we ask them to make that link to the broader context where they can. So audiences do understand that violence against women is not just a one-off act, but part of that ongoing pattern of violent controlling behaviour. So some of what you've mentioned there does sort of help to highlight why, the audience might not be able to sort of see that context shown in media reports. Is there anything else you wanted to touch on there about that before we hand over to Mark?
Look, I think the only other thing that's kind of worth mentioning is there are so many automatic statutory restraints which fall into this area that, and I know why they're there. They're Parliament's intention of protecting the people that are already vulnerable because they've found themselves in this particular personal situation. The problem for reporting is that most of them have to do with prohibiting the identification of people that are involved in these types of proceedings. And as soon as you start taking names out of reports, it becomes much harder, I think, for readers to not necessarily to engage, but to follow the report from perhaps day to day of court as it's being reported in the news. Or even to, if they were minded to look it up and try and find that same case, it's very difficult to do because you can't search by Joe Bloggs or Gina McWilliams because the name's not there. Now, so you're kind of caught between a rock and a hard place because you can't do it. It's unlawful, but at the same time, it is something which would, I think, make reports about this area a lot more fulsome and accessible to readers, and I think that's really important. So
thanks for that, Gina. Mark, I might turn to you now. So you recently retired as Professor of Journalism and Social Media at Griffith University, but you've had a long history of working in media law and ethics. Aside from being a lecturer, you have been published in a range of publications, including the Wall Street Journal, the Far Eastern Economic Review, Crikey, The Conversation, and ABC's The Drum. You're also an author with 13 books under your belt, including writing Australia's leading journalism text on media law. So apologies for dragging you out of retirement, Mark, but we are so thrilled to have you here today to lend your expertise to the session. Firstly, I'd like to know if you have anything to add to Gina's earlier comments on the legal risks in reporting on violence against women.
No, I think Gina has probably done the world's best possible 15-minute summary of the area and applying it to that. I guess the trouble is for anyone, taking it all in, which is probably where I try to do things with students, but not within a 15-minute period. But first of all, I'd like to pay my respects to the traditional owners of the land I'm on today, which happens to be the Yindinji people at Yungaburra in Queensland, because I just happen to be here this week. Normally the Kumbameri people of the Yugambeh language group on the Gold Coast. And I'm not fully retired. I've retired from that job at Griffith University, but I'm doing various other things, including maintaining the textbooks and little talking assignments like this. So thank you. Yeah, thanks, Rebecca, and congratulations, Gina, on a great job.
Okay, so Mark, what advice do you have for reporters who might be new to reporting of violence against women, or those who usually report on different beats? For example, a sports reporter covering an athlete apprehended on a domestic violence order, for example.
Good. Well, first up, I am not a domestic violence expert. So, Gina's won a Walkley in that area. So, all I do is try to prepare students and journalists for the general area of media law and then apply it to particular situations. But as you do that, you find that there is a host of laws that might apply in a particular topic area like this. Just as, for example, business journalists need to know ASIC and the ACCC inside out, there are certain laws that fall into this domain. And as Gina said, the biggest ones are always the ones we're firstly on the alert for are, of course, defamation and contempt of court. And Gina hinted also at new privacy laws, and she might want to talk a little bit more about that later. We're not going to go into my 3 or 4 slides in huge detail. They'll be there in the resources for you. But during her presentation, Gina spoke about the 2 big areas of defamation and contempt. And what I've found with students and journalists is that it might be fine. Some of them might become expert at learning about one or the other and be able to pass exams and things and tell you what they all are. But a particular story involves the dance, the interplay between at least those 2 areas, and sometimes many more areas, as we've just heard in domestic violence. But for at least those 2 areas, these time zones give some indication of what to look for. Now, I'm not a practicing lawyer and I don't give legal advice and I don't work at the coalface every day. So I take no responsibility here. But nevertheless, when Gina said all of that about defamation and the truth defence, you might very well go out and get all of that evidence and be able to prepare a truth defence to defamation. And then she spoke about contempt of court, sub judice contempt, and also to do with suppression orders or non-identification orders. And for those latter areas, truth is actually no defence. So, for example, with contempt of court, your defences are basically a fair and accurate report of a court case or a difficult to prove defence of public interest. And we all know that the law has a much narrower view of public interest than an editor will have. So you need to be aware of where contempt starts in the time zones and where it finishes so that your defamation defence is going to be usable for both defamation, but you're still staying within the boundaries of contempt of court. And as I said, it's not going to protect you from a suppression order or even in some of these cases, the bigger cases that we've seen, the super injunction, where you're not even able to report the fact that there is an injunction in place, which we've found occasionally the big media organisations falling for. So what I have to work with particularly students is how are they going to know that a certain situation is arising? And that might depend on the actual situation or their own emotion that's involved, where they really do need to sound the alarm bells and go into this recognition that they are in a difficult situation, either legally or ethically. And so a table of situations and emotions, and this actually in the textbook goes into several pages, but the first one here that you may or may not be able to read on your screen is actually a situation and an emotion where you are too rushed to check or you are feeling you're out of your depth at the moment. Now, that has certain ethical risks attached to it, as you know, because the sort of mistakes we're talking about can arise then. but also ethical and legal risks, because so many of these defamation and contempt cases have been media organisations, individual journalists, sometimes inexperienced, often without legal advice, because, you know, Gina's working for News Corporation, one of the, you know, along with 3 or 4 others, the rarities where journalists are actually able to access a lawyer for advice on a breaking story. But if you're an independent publisher, a podcaster, a blogger, you know, a social media user, you don't have the luxury or the account balance to be able to ring a lawyer to be able to get the advice. So you really do need to know when to pause to reflect. And that reflection will involve both your own moral values, your ethical code of practice, because unlike a lawyer, I'm also looking at the ethical dimensions of most of these situations. I know lawyers, I'm not saying lawyers are unethical, but their main task is to help you navigate the legalities. And in many of the larger corporations, that means how can we get away with it, even if it might be a little bit unethical in the ethical code and so on. So there's your individual moral code, and then there's the professional ethical code. And most journalists, sadly, can't say much about their code of ethics other than they shouldn't reveal their sources. Okay, so the rest of it's, you know, a bit of a vacuum for them. But many elements of the code of ethics to do with, you know, invasion of privacy and confidentiality and so on do overlap with this area of domestic violence. So you really do need to have an extra look at the ethical code. And then, of course, the legal risks of the situation you need to look at. So situation, emotion should trigger your reflection and going back to your research. So the next slide, please, Dan. The tools for reflection. What tools do we have at hand? We're in a 24/7 newsroom. Our competitors are on the story. They're about to break on their hourly news bulletin. There's 3 minutes to deadline. We've got the name of the accused that someone's told us, and we can beat them to this scoop if we get that to air first. You know, that's the situation. Well, those alarm bells are ringing. What do you do for that reflection? And the trouble is, in 24/7 newsrooms, there isn't a lot of time. You can't go into the lotus position there in the newsroom on the editor's desk and have a 15-minute breathing meditation to think through the problem. But you might be able to go into a mini meditation or reflection of your choice, at least a little bit of breathing, some 3 deep breaths while you think through why you're feeling this way and what the issue is. Perhaps a walk to the bubbler or the water fountain while you think through the dimensions. Whatever, perhaps a toilet break where you just sit there just for a couple of minutes to think through the situation. That's one way. Journaling is another. Journaling as in taking a few notes. So we're all writers, most of us, and taking a few notes around the situation can be really useful. Of course, this needs to be informed. So you need to have done some quick research into the area that has rung the alarm bells to know the background. Perhaps you go to our Watch seminar notes, which has everything that Gina just said in there, and it helps you recap what you need to be looking for. Some people are more graphical, so they would do mind mapping around those issues, a big circle for defamation, an overlapping circle with contempt, identification restrictions, suppression orders. This is all sitting there in the middle, and they realise they have to be on top of all of these things to address this properly. This should prompt a serious discussion with your colleagues, perhaps your mentor or your editor or news director, perhaps that senior journalist who's sitting at the other desk or is on the phone nearby, so you can quickly get some feedback on the situation and some wise counsel about it. And of course, legal advice isn't there as the last one. If you have in-house counsel, that's where you might be going much earlier in the piece. But of course, the cost of legal advice can be prohibitive for small publishers. So in those situations, it may be last, but it means you do have to do it, because $200 for that answering that one question in a few minutes may be $20,000 you've saved in the process. And the next slide is just to do with some resources and what I found in researching for this was that already sitting there on Our Watch is an excellent resource on tips for reporting when there are legal restrictions. And that provides a wonderful nutshell summary of most of the things we've been talking about and many more to do with domestic violence. And I hadn't been familiar with Annie Blatchford's work that she did for her PhD, but I'd really thoroughly recommend this to you. And if you're working in the area, I recommend you go ahead and look for a bit more work by her because it's been really well researched and put together. My work with my colleagues, the other one on online safety of diverse journalists, which was published recently. The law changes quickly. There have been a few laws changed since 2023. But that was led by Faith Valencia Forrester with a multi-university research team. My main responsibility there was producing the appendix, which was a 5,000-word summary of laws to do with this general area, particularly in the online area, the area of online safety for journalists, which does overlap a little bit with this because there's a lot of it to do with the online safety of minority, diverse journalists in various ways, but including international research on female journalists and how they're so much more subject to online harassment. So they were my slides, and that was my little summary. In a nutshell, I would say it's mainly, for me, it's mainly a combination of actually knowing the law, and maybe some of you are at university and you've got a high distinction in your media law class. Well, I'm sorry, that 95% for media law is of absolutely no use to you unless you can pause to reflect on the situation at hand and learn and to recapture that knowledge to actually apply it to this scenario that's facing you on the domestic violence front. Thank you.
Thank you so much for those important considerations, Mark. Elena, I might ask you to come off mute and join us now. So, Elena, in your role as Associate Director at RMIT Centre for Innovative Justice, you research, advocate and apply innovative ways to improve the justice system. I'd love you to bring this expertise to reflect on what has been said throughout the session today. What changes would you like to see made to the criminal justice system that would improve outcomes, both in terms of justice for victims of violence and for a journalist reporting on this issue?
Thanks so much, Rebecca. And I'm also very privileged to be joining from the lands of the Woiwurrung and Boonwurrung people of the Eastern Kulin Nation here in Melbourne, Victoria. And it's been really fantastic listening to Mark and Gina's reflections and expertise. I am a lawyer, but I'm not a media lawyer. Although I was just reflecting, Gina, as you talked about the devolution of the uniform defamation laws, because in a previous role I was, helped bring those uniform defamation laws together, and it's a really, really confusing environment. But one of the things I was just reflecting on as we were talking about that is the really worrying way in which, because of the significant limitations of the criminal legal process, the prosecution process, how infrequently something goes from reporting to investigation to prosecution to actually conviction. The civil side of things, including defamation, but not necessarily limited to it, has become a quasi-prosecution forum in which where those protections and where those kind of considerations that Gina and Mark have so carefully laid out are not observed, or even if they are, people who may have been accused of, either in the context of a prosecution process or more generally outside that, where there are allegations made, bring a defamation action, as Gina flagged, sometimes in the context of further sort of systems abuse and further coercive control. And we have a very, very weird situation where to the wider community, that's the forum in which someone's kind of the allegations are aired, where the truth of the matter, the credibility of the victim survivor concerned is aired, and where we sort of find this sort of strange situation of somebody either having been assumed to have been proved innocent, which is not a thing. You can't do that. You can't prove someone innocent. Because they're innocent until they're proven, until the charges are proven guilty. But we've had a strange run of a few kind of very high profile male celebrities or otherwise being seen by the court of public opinion to have been proved innocent when a defamation action that they bring is successful. And obviously we're all very, very aware of the case involving Bruce Lemon, in which through that process, he was seen in the court of public opinion to have been proven that he had raped Brittany Higgins because of the way in which he was found in that defamation action wasn't successful, and the federal court judge made certain comments in that regard. So we're in really, really interesting territory, and where I'm going with this is I want to bring in what that means in terms of how victim survivors of domestic, family or sexual violence are thinking about ever airing their complaints, because not only do they have the prospect of an incredibly re-traumatising, distressing prosecution process in front of them, but potentially these other risks as well. And so the responsibilities of the media are so significant, not only in terms of doing your job well and observing those legal restrictions and those kind of navigating all of those complexities that Gina and Mark have described, but thinking about what does this do to kind of essentially cover this? Is this actually helping to address and respond to domestic, family and sexual violence? Is it discouraging victim survivors from ever raising a complaint or making a report to police? And thereby, are we actually helping people who use domestic, family and sexual violence avoid accountability because of the way, like the ramifications of how that plays out? So that was kind of just one of my main reflections, and echoing particularly from the first session. If I may, I feel huge responsibility to echo the words of our fantastic panel in there, Christine and Zita and Anna, all of whom discussed and explored how important it was to have the victim survivor voice featured in media stories, whether it be obviously in relation to defamation, as we might have been talking about, or in relation to reporting matters in the criminal justice stream, but how, if not done carefully, can cause so much harm and further trauma to people who have essentially, and this is the most important point to perhaps to remember that Anna raised, is that the fundamental feature of gender-based violence is the removal of control and agency from the victim survivor. So not only has that happened, but then if they make a report, immediately it's out of their hands as well from police. There's very, very little, and my research shows really, 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 really unfortunately, really significantly how palpable the failure to really prioritise and investigate sexual violence matters, and particularly because of that difficulty in kind of airing the evidence and kind of finding those external evidence, unless somebody's actually reported at the point of crisis and there's forensic evidence available. So we know it's out of their control once they've reported there, and then as soon as it hits either kind of justice system, it's completely out of their control. And so then when the media comes in over the top of that, thinking about what that does to how the story is presented, assumptions made, language used, it's all incredibly significant. So, but there's an opportunity there as well at the same time to do great work, the way Gina and Nina Fennell have done in terms of their work and others, to return to use that process as a way of carefully and collaboratively returning agency to the person who's experienced the harm in the first place.
Yeah, that's such an important reflection, Elena, because we know that there's that inherent tension, isn't there, that exists between giving that voice to victims and then the journalist legal restraints. And we've obviously also seen in that reporting that when there's a failure to navigate that effectively, that impacts on the success of the victim's case. And at other times, as we heard earlier, efforts to feature the voice of a victim survivor might result in re-traumatization, loss of agency, and due to the way that the information was handled. Do you have anything further there to sort of say around, anything that from how journalists might be able to contribute to the ongoing safety of victim survivors in that space when they're reporting, Elena?
Well, I just reflecting on Mark's comments and about the need, recognising the vicarious trauma that comes from, extensive coverage of domestic, family and sexual violence, thinking about sort of essentially the human element in the entire experience. So what does it do to anyone practicing in this area, working in this area? Where we've talked and previously about how there are many people who in some professions have reflective practice. They do take time to step out and consider their experiences and what it's doing to them. Taking that meditative moment, as Mark has said, in some professions like the legal profession of mine, particularly criminal justice lawyers, there's no such thing, and we just kind of proceed and potentially use dark humour and a significant glass of Chardonnay at the end of the day to get through the process. But when you're thinking about what does all of this overlay, what is this doing to me? Then what is all of the airing of this information doing to people, not only the victim survivor directly affected, but anybody else who's experienced it and seeing the way this is all playing out? And I think perhaps an interesting reflection is over a year ago, we were seemingly suddenly in a crisis in relation to domestic and family violence, homicide, the murder of women. And we were recognising that, and we recognised it as a sort of a national emergency type of situation. The government called a rapid review, and of which I was a part, and the media's focus was really, really significant. And there was an interesting kind of phenomenon occurring at that time where, for so long, people working in the sector, including our watch, have called for the media to do better in terms of recognising that this is the murder of women. This is recognising domestic homicide of women as for what it is, and not kind of diverting to really kind of descriptions that don't really kind of capture what has occurred and minimising it and things. But what we were seeing last year was almost the opposite of that, where it was becoming a real kind of voyeuristic almost, where the constant coverage of the constant murders was having a massive effect on people working in the sector, because they're already up to here with the trauma. They're already dealing with that the whole time. And so while we've got a really important responsibility to explain to the wider community what is happening and what it means and what it involves, what is that doing to the people who are actually responding to this every day in their workplace, as well as the people who are actually victim survivors of that as well. So I don't have an answer but it was really, I really noticed people who work in this sector, we unfortunately very, very used to the fact that significant numbers of women are dying all of the time, and children who never get mentioned. Kids never get mentioned for the reasons that we've explained. But it's a funny thing. It's an extra layer to have it forced on you every time, at everywhere you turn. So that's also just something to think about in our shared responsibilities as we try and do better about how to convey the significance of the prevalence of gender-based violence in Australia.
Thank you, Elena. That was yes, such an important insight. I might actually throw to you, Gina, sort of on the back of what Elena was saying. You know, were there? I mean, you know, especially given there was that you know, a huge number of cases last year, and there would have been you know, a lot of media interest on that. You know, what if there was additional considerations that you made to keep that you know, to cover that, and yeah, just be interested to hear your reflections on that as well.
Yes and no is the slightly frustrating answer. Yes, because we well, both News Corp and there is a body called Australia's Right to Know, which is not a formal corporation or anything like that. But whenever the media in Australia has a shared issue, which actually comes up a lot more often than you would think, we use that vehicle to voice what we want to say about whatever it is that's happening. And when we use that most often is when it comes to legislative reform. And that there's actually been a huge wave of that, which maybe even predated what Elena was talking about in terms of that flush of deaths that kind of happened in the last 18 months. Coercive control in particular seems to be something that parliamentarians have been wanting to grapple with for quite some time, and the other kind of classes of domestic offences which sit with that. But before they legislate that, they always have an inquiry and they get people in to talk about it, and they have a think tank and they come up with a draft, and will often be involved in that side of the process. That was particularly the case in Queensland over the last 2.5 years. The Hear Her Voice reports up in Queensland, which were the result of extensive community consultation, which just got broader because, as you know, they had 2 very unfortunate deaths in that part of the world that were quite shocking and did result in Parliament wanting to really find ways to assist and try and ensure that it doesn't happen again. So yeah, we made submissions. We appeared in the Senate committee inquiries into the draft legislation that was produced as a result of that report. I think that was Helen McMurdo that led that one, the former judge. So yeah, that's separate to that. Obviously, in the 24-hour news cycle that Mark was mentioning, if it's a story about a murder, it's going to be in the front 5, because using newspaper parlance, because you know they're very important cases to be reporting about. And then it's just a question of, well, how much of it can you actually report? Because do you have already somebody who's been arrested and charged? And as Mark said, do you already have a sub judice contempt problem? Have you already triggered automatic statutory restraints, which means you can't identify particular people who are involved in proceedings which seem like they should be extremely newsworthy and reported in the most fulsome way that can be done to inform the public, but as Elena was saying, also balanced to try and not make it too gruesome or overly impactful. Yeah, sorry, that didn't really answer your question, but that's what we do.
Yeah, no, it's a really you know, and those considerations are you know, are complex ones. I might pop everyone, you know, bring everyone together now. We can sort of talk, you know, together. And I'd love to hear from, you know, different ones of you if there's things that have emerged out of that conversation today that you feel like you'd like to unpack a little bit more. I know that there is, you know, there's been so much that's been covered, and it's a really, you know, a really important area to sort of unpack a bit more. There was something that was said earlier, so, and I might just get either Gina or Mark or Elena to expand on further. But you know, if we have a victim who would like disclosure, but the courts have granted name suppression to the perpetrator, do you have any sort of thoughts about how journalists should respond to that sort of story?
I have a point I'd like to make that's partly related to that, and that is we're dealing with a whole lot of different literacies here, or illiteracies and ignorance, and part of what Elena said was to do with, people not realising that not guilty doesn't mean innocent and so on. And knowledge and education is power. So the people in this seminar are trying to address or improve their legal literacy in the area of this, which is, a pat on the back for being here to want to do that. But society generally has quite a low level of legal literacy, about, civics, about how the system works and why a civil case might be different from a criminal case and so on. They have very low knowledge on that. They have minimal media literacy about who is giving them a particular message, what's the backing of that message, why other people are making similar comments to them in a social media channel or whatever. And probably they have a low level of domestic and family violence literacy. It's very hard to train all of society in all of those areas at once. But we've learned that journalists who learn more about these areas and make a reflective decision are less likely to get vicarious trauma as a result of the course of action that they take, because they've thought through that. And I'm wondering whether, not being an expert, I'm wondering whether victim survivors might be more empowered if they actually had materials and training in the law of this area and in the media and how it handles it, so that they are able to see through the training that it's not about them, that the media might not be naming them or identifying or assuming the guilt of the accused, that there are legal and media reasons why these things happen. And in understanding that, it might reduce to some extent their qualms about either the media or the legal system's way of handling it.
I'll jump in and just give you the legal bit. Perhaps if you do find yourself in circumstances where there is a non-publication order in place in a case where you have the full cooperation of the person who is the victim survivor, if you don't have general access to legal resources, that might be an occasion where you might want to scrape around and see if you can get some, because generally speaking, the fact that the person who is the complainant in the case wants a non-publication order overturned is very powerful when you take it to a court. So if you have the resources to seek some legal advice, then that's probably one of the times that I would recommend that you do it. Now, separately, you do want to check at the same time that there is not an automatic legislative restraint operating in the same area, because you can get a court to revoke an order, but you might at the same time need that same court to make an affirmative order, allowing you to do something that the automatic statutory restraint does not allow you to do. And that is exactly what happened when we worked with Nina and the Millthorpe family, because one of the girls was too young for anyone to give consent to her being identified, despite the fact that she desperately, desperately wanted to tell her story in her own voice. And it turned out that at some point a non-publication order, which doubled up on prohibiting her from being identified, had been made. So when we did that process, we were able to go to the court and say, okay, everybody wants this order gone. Here's the reason why you should get rid of it. And they were happy with that. And also, this is a person who, despite her young age, has had independent legal advice, has an incredibly supportive family and wider community network. She knows what's going to happen if she's allowed to name herself, because we've, talked to her over and over and over again about what's going to occur, and she still wants to do it. So we say that you should make an order letting her make that decision for herself. And I just add, when it comes to somebody who's that young, we genuinely hesitate to do it, but she was just so impressive and so clear about what she wanted that it was like, okay, I'll do as I'm told.
And that's such a powerful example, isn't it, of when, you know, you have really empowered the survivor to tell their story, and you've got that, you know, that deep legal knowledge, you've investigated everything, you've got the whole support structures there. And I think that's something that is really, you know, a fantastic achievement from all parties concerned. So, you know, I was following that at the time, and, you know, and I know from talking with Nina, some of the complexities that went into that, and, you know, that was just so well handled. So, you know, it was a really good a lesson in how to do things well. So I might just pause here before we go into closing comments, and just ask people to tag at your phones. There's going to be a QR code that's going to pop up on the screen shortly. So there's a quick 60-second survey on the session today, and we'll also pop the links to that into the chat. It's entirely voluntary. We do appreciate your feedback. It does help us to get a sense of effectiveness of the content for evaluation and our ongoing work in this space. And it's also an opportunity for you to contribute your comments on how you felt like the session went today. So in closing, I mean, the session has shown that while there are significant challenges for journalists in reporting and adhering to some of the legal ethical constraints when reporting on court cases of violence against women, there is a lot to be gained as well when you are confident in your understanding of the law. Journalists do hold a unique and significant power to shape news narratives and to promote systemic change through the coverage. And whether it's to hold those who commit violence to account, or challenge problematic or outdated aspects of the criminal justice system, or to sensitively uphold the voices of those affected by violence. As a media professional, you play a much needed role in the prevention of violence so that everyone can thrive and live in safety. In closing, let's go back to panelist view. I would love to hear from each of you, Gina, Mark and Elena, to share what you would like attendees to go away with from the session today.
I would just like, as someone who does, has done research in this area for a very long time, as important as it is to share and highlight the crisis of gender-based violence that faces Australia and, you know, every other country around the world, to hasten slowly in terms of rushing into the fray if you're really not confident that you've worked. That you understand the nuances and the complexities, yes, of the legal obligations, but also of some of the significant systems harm and factors that influence the way in which not only victim survivors, but victim survivors from particular backgrounds and experiences are portrayed. The magic ingredient that we would all like to see, and I recognise is a challenge, is time, and time to work kind of to get your head around what's happening, time to work with a survivor or a victim's family, where those kind of situations allow, and investing that, because it'll pay dividends. It'll pay dividends for the actual particular report. It will pay dividends for how you're seen and regarded as a journalist to whom other people will kind of trust in the future. And it will pay dividends then to how the issue is understood more broadly in the community. So if you can advocate all around you to the people who put the pressure on, see if you can take the time to get it right, and we'll all see the benefits in the future.
Great. I might pass to you, Mark.
My final message is think before you act. We heard Justice Lee's famous statement in the Higgins-Lee case that it became an omni-shambles, and we have to remember in our actions as media professionals that there is a ripple effect of our actions. And while in that case it was nationally and internationally publicised, that ripple effect, and we saw the terrible impact on so many people's lives, that happens on a scale in every one of these sorts of cases. And the cases I've seen through my career in media law, if the reporters involved had done a little bit more reflecting before they acted, there would be so fewer defamation payouts, journalists being jailed, all of these sorts of things happening. A tiny bit of reflection can save a whole lot of heartache for a whole lot of people.
Thanks, Mark. And that's a perfect soundbite to leave this webinar on. We could talk about this all day, but we are at time. Just to wrap, do remember to reach out on some of those support lines if you need. 1-800-RESPECT, there's the men's referral service there, 13 Yarn, Q-Life, or Lifeline. And if you please reach out also to our media relations team. There's a phone number and email provided on the next slide if you want background or comment on the story, or you can reach out to the prevention and media team on the Media Making Change email there for training and resources, as well as signing up to our newsletter to hear about upcoming events and opportunities. A huge thanks to a brilliant panelists for the session. Mark, Gina and Elena, your wisdom, expertise and humour have provided some much needed clarity on this complex and serious issue. And I also want to thank Zita, Christine and Anna from our earlier session. Thank you again for your steadfast and ongoing advocacy for survivors, as well as those who have passed due to men's violence. Thank you, Carmela, our digital support, Dan and our watch. Have a wonderful day, everyone.